Welcome to today's program titled Post-Dobbs Implication for Employers and Employer Plan Sponsors. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen and pressing enter. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Diane Dygert. You may begin.
Thank you, Ainsley, and welcome again to our client webinar on Post-Dobbs implications for employers and employee plan sponsors. The first thing I have to do, unfortunately, is read to you our legal disclaimer. If you've sat through these webinars before, you know that this presentation is prepared for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. So that out of the way, why don't we start? We have a lot to cover today. You can see our agenda is chock full of everything you want to know about this issue. We're going to start with Ada Dolph, who's going to talk about the Dobbs decision itself to kind of lay the groundwork for us, level set everyone. And we're going to turn it over after that to Leanne Rodriguez, who's going to discuss the state governments and the federal government reactions thus far. It's a moving target, moves every day. And from there, then we're going to focus on the employer options. Both Jennifer Kraft and Danita Merlot are going to talk about the benefit coverage side of it. And then Elizabeth Levy and Anne-Marie Zelatel are going to talk about policy issues, discrimination, leave issues, those kind of things. And then what a lot of us are waiting for, Ben Connolly and Chris Robertson are going to talk about employer risk, ERISA Preemption, and the criminal side of this as well. And then we'll conclude with how we can help you. So without further ado, I am going to turn this over to Ada Dolph.
Thanks, Diane. Good afternoon, everyone. We do, as Diane said, have a lot to cover, and most of us are familiar with sort of the punchline from the Dobbs case, so I won't belabor it, but I do want to hit on a few points that certainly will impact us going forward. So the first piece, which most of you are familiar with, is the, oops, sorry, we had a delay in the slides here, is the holding. So without further ado, the Supreme Court held that the Constitution does not grant a right to abortion, that Roe versus Wade and Planned Parenthood versus Casey precedent that's been in place for, in the case of Roe, nearly 50 years is overruled. And then Dobbs, as it states, returns the power to weigh these arguments in favor and against abortion to the people and their elected representatives. I have it listed here as a 4-1-3 decision, and that's because Justice Roberts wrote a separate concurrence in which he concurred only in the judgment that he would have held this statute at issue constitutional, but he did not join the portions of the opinion that overruled Roe and Casey and some of the other reasoning as well, which is significant. Go to the next slide. So the case, the court posed three primary questions that it indicated it needed to answer in order to decide this question. The first question is, does the Constitution confer a right to obtain an abortion? And the answer to that question, after looking closely at the text of the Constitution, which was a primary focus of this decision, is no, according to the Supreme Court. There also is contained in here very sharp criticism of Roe versus Wade as a, quote, abuse of judicial authority, with the balancing test that was announced in Roe versus Wade and then reiterated at some level in Planned Parenthood versus Casey. The next question, and there's a lot more detail on some of these slides, but we'll just move through this. The second question the court posed was whether the right to an abortion is, quote, rooted in the nation's history and tradition and part of what it termed ordered liberty. So basically examining whether an abortion right is part of the substantive rights found in the 14th Amendment. And for this answer, the court focused quite a bit of time in the opinion on the state of the law at the time of the enactment of the 14th Amendment, which is 1868, and concluded that at the time of the enactment of the 14th Amendment, there was no right to an abortion, that the majority of states prohibited abortion at all stages of pregnancy. Therefore, the amendment, according to the justices here, could not contain a right to an abortion. The third question the court posed is whether the right to an abortion is part of a broader entrenched right supported by other precedents. And here is where the court repeatedly attempted to draw a line between this decision and other rights and precedents that have been also found in the privacy right inherent in the 14th Amendment. So here the court said, what sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely, which, as we know, include Griswold, for example, and Loving versus Virginia, is something that both those decisions acknowledged. Abortion destroys what those decisions call potential life and what the law at issue in this case regards as the life of an unborn human being. So the court will continue coming back to that theme that this is a standard only that pertains to the right to abortion. And I skipped ahead a slide here. There are some quotes that are fairly significant in the opinion that attempt to draw that line. So for example, at the end here, nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. The court, significant for us in looking ahead and for the information you're going to be getting after me, is the new standard announced by the Supreme Court for reviewing laws regulating abortion. The Supreme Court, as you may recall under Planned Parenthood versus Casey, typically followed a substantial burden standard, which prohibited a law if it was a substantial burden to abortion before the fetus attains viability. The new standard announced disposes of any viability construct or the trimester construct that we've been familiar with and applies a rational basis standard. It went on to specify that a law regulating abortions, like other health and welfare laws, is entitled to a strong presumption of validity. And it said that the state essentially needs to demonstrate a legitimate state interest. It went on to state that a legitimate interest does include respect for preservation of prenatal life at all stages of development. So as the dissent discusses, and I think it's fair to say from that standard, we expect most laws regulating abortion to survive under this pretty lenient standard. I'll just mention a couple more points and then I'll hand it over to our next presenter. The concurrences in this opinion are significant, as I mentioned before. Justice Thomas wrote a concurrence that, as the dissent said, is not with the program. He went ahead and, while these serious lines are drawn throughout the main majority opinion between abortion rights and other privacy rights, he advocates for the eradication of all substantive due process rights using essentially the same formula as was used in Dobbs. Kavanaugh tried to provide some reassurance, which may have some persuasive effect here, where he said that a state could not prohibit a resident from traveling to another state or punish a person for an abortion that occurred pre-Dobbs. But critics have pointed out he certainly doesn't go any further than that, and he doesn't assert that there is some constitutional right that would protect someone who had assisted someone in obtaining an abortion in another state or obtained an abortion in another state. Justice Roberts, as I said, concurred only in the judgment, and he stated that the majority misrepresented that they had no other options, which seemed like very strong language for him. But again, he concurred in the judgment. And then the dissent pointed out many of the things that I've talked about so far, that we expect most laws regulating abortion to survive under this very lenient standard. And pointing out that this heavy reliance on the history, in effect, as of the implementation of the 14th Amendment, means that all rights that have no history, stretching back to the mid-19th century, are insecure. And in addition, the majority opinion gave fairly short shrift to the importance of stare decisis and upholding Roe v. Wade and Casey on that basis. And the dissent here calls this decision a loaded weapon pointed at other rights for that reason.
Okay,
Thanks,
so
Ada.
this is
I'm gonna. Oh, sorry, Leanne. I was going to turn it over to you now, but sounds like you're ready to take over for the state and federal
all right.
reactions.
Thank you, Diane, and thank you, Ada. No sooner did the Dobbs decision come down, and in fact, to a degree before the Dobbs decision was handed down, a number of states, generally states that whose legislatures and governors were interested in either banning abortion or implementing banning abortions quickly, moved into action in order to make those laws a reality. I think it's a good point to point to Texas in particular. I think as all of this unfolds in the months and years to come, Texas will often be the vanguard of anti-abortion states in terms of both implementing and then enforcing particular types of laws that in some way or other restrict or fully ban abortion. So the question then becomes, where are those laws? When are they going to become effective? And what do they say? As everyone starts digging into these laws, important to recognize that many of them were drafted at a time where people didn't even imagine that a decision like Dobbs was possible, or that it was a distant dream. So there is in these laws left a tremendous amount of uncertainty. And so there are going to be a number of legal questions that are going to come up as time goes on with respect to what these laws say. So the first sort of major class of laws were laws that were already on the books prior to Dobbs, and were what were termed trigger laws. In other words, they were not actually effective in any regard prior to the Dobbs decision, but they were designed to go into effect immediately upon the Dobbs decision. In I think one or two cases, there is some delayed effect to those decisions where they can go into effect, say 30 days after the decision was handed down. So here you see a map of where those states are. Interestingly, one of those, Oklahoma, actually stopped providing care even before Dobbs went into effect. The possibility of these bans actually, in many cases, already inhibited physicians and clinics from providing service, and caused them to start going out of business already in some of these states with laws of these types. There are also a couple of the laws that required gubernatorial certification to go into effect. There were also states that had technically effective laws prior to Roe v. Wade. And so this is this small group of states that you see here. You'll note that there's a little bit of overlap among these categories because there are different parts of these laws. Of course, there was no enforcement of these laws, and of course, abortion services were being provided in these states before. But now, of course, these laws are effective, and at a minimum, Texas will actually be enforcing that law. I think that's going to be one of the big questions as we move on to the other slides. Is first is the question of what laws are going to be out there, but then what enforcement mechanisms will go into effect. There are other bans that will become effective. Ohio is an example of one of those. And there are states that are moving as we speak to ban. Again, these are examples: Florida, Michigan, and Montana. And significantly here is, we're talking about a lot of big states. So this, could be perceived as a phenomenon that is only taking hold in, smaller, relatively unpopulated states. But, when we're talking about Texas, Florida, Michigan, Ohio, Arizona, we're talking about big states. So the potential national impact of this is indeed pretty significant. So what are the states actually doing? Some states are resisting implementation of their own laws. So in Michigan, you do have Governor Whitmer, a Democratic governor, very vocally pro-choice. And so she has actually had her lawyers go to court in order to attempt to have the effectiveness of the law enjoined. As of right now, that attempt to enjoin the law has not succeeded, but the court proceedings will continue. There's similar effort in Florida to stop their law from going into effect. There are also one or two states where governors have indicated that they will pardon individuals who have violated the law. How effective that will be, it's a big question. I also want to point to a number of blue cities, in other words, cities with Democratic mayors that have said that they will not prosecute violations of the abortion laws. Whether that counts, whether that matters or not, will depend on what the Attorney General's office is. And then before I hand off the baton, the one last and critical thing I do want to point out at the state level is Texas has already stepped out and said that employers, so a group of state legislators, to be fair, they haven't actually done anything yet, but a group of state legislators has already stepped out and said that they think that the paying for abortion services out of state is something that should be criminalized. So we can expect to at least see some efforts in the Texas state legislature to pass a law that basically says that bans employers and potentially subjects them to criminal penalties. Will states use Dobbs as a basis to address issues beyond abortion? I think Ada highlighted those risks. I think the key thing I would add here is the fact that the Texas governor and the Attorney General have said they're thinking about it. They're willing to go beyond abortion to same-sex marriage, sodomy laws, contraception, to defend those kinds of laws in the future. And then, of course, there has been pretty significant pushback at the federal level. There's been a lot of pressure on the Biden administration to really limit to the greatest extent possible the manner in which states will enforce the laws we were just talking about. Of the ones you see here on this slide, I would in particular point out to the application of EMTALA and reminding states that providers should retain the option to provide emergency services, including including abortion services where necessary. There was also an HHS announcement today targeted at pharmacies. And with that, I will turn over to Jennifer and Danita, who will be talking about the benefits implications.
Thanks, Leon. So as Leon was mentioning, we have all sorts of laws in different states, and also the possibility of action against employers for reimbursing and paying for coverage. So that goes directly to the issue of medical plans. You know, a lot of companies have medical plans that cover employers across many states. So the first thing to do from an employer perspective is really assess your plan, your medical plan, where you have people, what states you're covered, what the laws are in that state, and what your plan currently covers. I think a lot of our clients didn't necessarily know the nuances of what their plan was covering. So looking at whether your plan covers elective or non-elective abortions. Any abortion from a tax code perspective is considered a medically necessary and permissible, to be covered under a plan, but some plans will, have various provisions related to elective or not elective that are covered. Pharmaceutical contraceptives, so like the Plan B pill that would prevent someone from becoming pregnant, whether those are covered under the plan, as opposed to abortifacient drugs, which actually would cause an abortion when someone is pregnant, checking to see whether those are currently covered under the plan, and if so, are they in a specialty drugs category, or do they require additional copays, kind of understanding what the coverage is and if it syncs with what the employer intends it to be. Looking at telehealth and whether you offer telehealth, this can come into play and be a concern if a telehealth provider can prescribe an abortifacient drug to somebody who's in a state, and if that state provides that's illegal, that could create issues. So kind of understanding what those benefits are under your plan, as well as whether your plan currently covers any type of travel benefits. A number of plans will have some sort of travel benefits. Traditionally, they've been for things like centers of excellence, or where we are, somebody's going for a transplant and the plan would cover certain medical expenses, and there's some tax considerations there that Danita's going to speak to in just a moment. But I think first understanding what your plan provides, and then deciding if that syncs with what the employer intends, what you want it to provide. If you're a fully insured plan, you don't usually have a lot of choice on what's covered or not covered under the plan, and fully insured plans need to be registered with the state insurance commissioner. So if some of these abortion services are illegal under the state law, then that is not going to be approved under the fully insured plan. But self-insured plans would have some options here. One of the things to consider is making sure the language provides that these services are only covered where they are legal, where the services are actually being provided. And that will help protect the employer from the types of issues Leon is talking about. You also want to talk to your third-party administrator to see what sort of things they can help with as far as administration in these issues. As we look at kind of the design piece of that from a self-insured side and from a fully insured side, there may be things to consider if employers want to provide some sort of travel benefits. We've seen lots of travel benefits issues in the news. There are ways to do that. Certainly for self-insured plans, the easiest way would be through the self-funded plan. If you already have a travel benefit or expanding an existing travel benefit, just getting to understand what your third-party administrator can do with respect to helping administer that. The good news with those types of programs is that ERISA still applies, which could be helpful for preemption arguments that Ben's going to speak to in a few minutes. It's also helpful because HIPAA would apply, which means there would be some privacy protections in place related to those benefits and people who are utilizing them. And the third-party administrator generally could administer that. One of the potential issues to think about is whether you want to limit that reimbursement to what's permitted under the tax code. And again, Nita will get to that in just a moment. For those, even if you're considering it under your own plan or outside of that medical plan, you also want to think about high deductible health plans and how any type of travel benefit might impact whether somebody's eligible to contribute to an HSA. And that may be a little bit tougher to track if it's outside of the current medical plan, but there are ways to provide travel benefits that would be outside of the existing plan. We have some of them listed here. The Employee Assistance Program is an idea where you would basically be able to provide some type of kind of limited travel benefit within the EAP. This would have the benefit of still being an ERISA plan, still having the ERISA preemption. The Affordable Care Act, for those of you who are familiar with that space, has certain requirements for any group health plans. So one of those requirements is you need to cover all preventive coverage, all preventive care services at 100%. So there is a concern if we kind of take this outside of our traditional medical plan, have we created another group health plan that we're then, subject to? But there is, subject to these ACA requirements, there is an exception for accepted benefits. Basically, if the program doesn't provide significant benefits in the nature of medical care, then it could be considered one of these accepted benefits. It also would need to meet a few other requirements. It can't be coordinated with another group health plan, can't charge a premium for it, and the program can't have any cost sharing, but those would be pretty easy to do. The question would just be whether kind of providing this travel benefit would be considered a significant benefit in the nature of medical care. Arguably, it's not, and this accepted benefit provision would apply, and you could provide these benefits under an ERISA and HIPAA provisions and be able to offer these types of benefits. Similar approaches would apply for a health reimbursement account, kind of employer money paying for these. We've seen some employers who may have employer funds already established think about whether they might reimburse some of these expenses. That's kind of a lot to go through if you don't have that already up and running, but if you do and this is a permissible expense, that might be a consideration. The other idea is just post-tax, just providing people reimbursement for travel and not asking a lot of questions and just taxing them on those funds, not trying to fit within the tax exemptions. The downside to that is then you don't have that ERISA preemption argument, which could become important down the road, as well as the HIPAA provisions wouldn't have in place. And real quickly, before I turn it over to Danita, two other things: the HIPAA privacy concerns for anything benefits that are covered under a group health plan, including travel benefits. HIPAA does protect that information in general. There are some provisions under HIPAA that do permit a health plan or provider to disclose information if it's required by law or for law enforcement purposes or to avert a serious threat to health or safety. HHS has issued guidance related to this, reminding providers and group health plans that they are permitted to but not required to disclose in those cases. But there could be a situation where if law enforcement has a court order that requires disclosure of that information, that would be permissible under HIPAA, and the court order would require it. But the HHS has issued some guidance. We actually have an alert on it that you can find on our website that gives a little bit more detail on those. The other last piece is on mental health parity. If you are adding a special travel benefit, there's a concern that if we're adding something special that's targeted towards one service, is that going to be a concern under the Mental Health Parity and Addiction Equity Act? Perhaps. I think that the general requirement is that you can't have any more restrictive provisions for mental health services than you have for medical services. So if you have a broad-based provision that is out there, that would apply equally to mental health, and people could go and get services elsewhere. Also, if the travel service is related to people needing to get benefits that aren't available or legally restricted where they are, that could be a reasonable type of difference between that and other mental health services. I'm going to turn it over to Danita to talk through the tax consequences.
Jennifer. So from a tax perspective, Jennifer just spoke about different avenues within a health plan that we could provide abortion-related travel benefits on a tax-free basis. And that generally can be done if the travel is primarily for and essential to medical care. So this means that as long as there's not some significant component of vacation or other reason that the individual is traveling can generally be provided on a tax-free basis. So within these categories, the actual travel and transit costs are broadly eligible for tax-free coverage. So we have airfare, we had, it was reasonable, a coach ticket, mileage for gas, but capped at the IRS limit, which is currently 22 cents per mile. And then things like rental cars, buses, taxis, ride-sharing fees, those would all qualify. But beyond this, it gets a little bit more complicated. Hotel lodging may be able to be provided tax-free, but the service needs to be provided in a hospital or similar facility. And depending on where the abortion service is received, that may not qualify here. Also, this is capped at $50 per day per individual, so there's some inherent limit on the lodging benefits. Meals in this context are generally not going to be able to be provided tax-free. The meal needs to be provided within a hospital. So depending on the service, abortion services are typically provided on an outpatient basis. So while the individual may have meals while on a trip, those necessarily wouldn't be provided in the hospital, allowing that to be provided tax-free. Companion travel may also be potentially covered if the companions need it for the person receiving the services, or if the person traveling is a child. And it's important to note here that these are just the tax limits. These are not the legal limits on what a plan could provide. We're seeing many organizations design a benefit to provide benefits beyond the IRS limit, which is fine, because anything above that would need to be treated as imputed income, similar to how we see domestic partner coverage. For HSAs, FSAs, and HRAs, and Jennifer spoke a little bit on this, these are really the reimbursement type vehicles that employers may offer to reimburse Post-Section 213D medical expenses. These should all be eligible to be tapped for reimbursement here, whether it's the employee or the employer money in the account. One hang-up we're seeing here, and it is often discussed, is that these accounts are limited to only reimbursing Post-Section 213D expenses. And Post-Section 213D, which is the Internal Revenue section that tells you what's a valid medical expense, does not extend to illegal operations or treatment. While we'll discuss this, the travel piece of this in a little bit, we're fairly comfortable with the assumption that a travel benefit can be provided legally. So then you get to the question of whether the actual abortion service itself is legal, and you would have to look at the state. This probably isn't going to come up in practice. Either individuals aren't going to be able to receive abortions and services or in states where illegal, or if they do, the intent there is not going to be to submit that reimbursement to Blue Cross, UHC, Aetna. So I don't know if that's really going to come up in practice, the actual abortion service, but if abortion is attained where illegal, there could be some impact. Additionally, if you're reimbursing on a tax-free basis, the assumption there is it's medical care. So just be careful when designing for high-deductible health plan participants. Typically, you cannot receive medical care, subsidized medical care, before your annual deductible is met in order to maintain or retain your HSA eligibility. So we'll want to consider how we design the benefit here. There may be an argument that abortion travel benefits can be HSA compatible if they're not significant benefits in the nature of medical care, but that approach has not been blessed by the IRS, so caution with designing benefits here for high deductible health plan participants. Lastly, I'll just mention that state law may vary, and state law does not have to follow federal tax law. I assume we're going to see some divergence in this space with some portion of the 26 states that are targeting or criminalizing abortion, that they may remove the associated tax benefit with those services. And additionally, federal law can also change. So federal tax law can be changed through the reconciliation process more easily. And while under President Biden, we don't see that happening, but just to note that we're entering a time frame where abortion laws are going to flip-flop based on administration to administration or Congress to Congress, state legislature to state legislator. So however we design our abortion travel benefits, we'll just want to keep an eye on these things, and we may need to pivot if necessary.
Thanks, Danita and Jen. Before I hand it over to Elizabeth and Anne-Marie, just want to mention we are seeing questions come in. Many of these questions based on the travel benefit discussion in particular about what happens if our employees live in states where abortion is not available, criminal or otherwise restricted. I just want to, or an ERISA preemption. We will get to some of those questions in later topics, and also time permitting at the end of the presentation, we'll try to answer some of those questions. So just want you to know we're not ignoring those. Hopefully they'll be embedded in the discussion, but if not, we'll circle back. That being said, Anne-Marie and Elizabeth, would you like to address the other employment issues?
Hi, yeah, sure. So I know that we spent a lot of time talking about benefits concerns, and I think that that is where a lot of concerns are going to lie. But outside of that, there are some more traditional employment law concerns that I think employers should be mindful of as we try to navigate these waters. And I know, as we've said, there's a lot of uncharted waters here, and I think there may be some flip-flopping and a giant patchwork of rules and regulations to try to navigate. But at the outset, we can just sort of discuss some of the issues that we think will come up. So one thing that may come up as employers are trying to craft their policies are dealing with accommodation and leave issues, and looking at whether certain laws require providing leave for some period of time if somebody needs an abortion. Whether employers may want to do so voluntarily. And I think that in terms of the requirements, it's really going to depend on the situation. So for example, if you have someone with a serious health condition, the life of the mother is in jeopardy type of situation, something like that is likely going to be covered under some type of federal, if not state law as well. In terms of providing time off, you see we have this question here, whether an employer might face civil or criminal liability for providing accommodations or leave of absence. If you're in a state that's more hostile to abortion, it is sort of an interesting question. I mean, Leon had mentioned earlier, you'd see these certain, Texas in particular, certain states saying, that they're going to take issue with employers providing certain measures for their employees. And I think it remains a question to see if it will extend as far as providing paid time off, to go to travel out of state or to go obtain an abortion somewhere where it's legal. There may be overlap between employers that are providing travel benefits and providing paid time off for those types of considerations. But I think employers just may want to consider what they're making paid leave available for. It may be less risky across the board to provide leave. Just if you have PTO as opposed to PTO for a specific reason related to abortion, it's possible that could open up a can of worms on a few fronts. And then I know another issue that whenever there's a hot topic, certainly something like this, you have employees with very vocal opinions on different sides of different issues. So I think employers are also probably wondering how to handle discussions within the workplace, what they can and can't do in terms of limiting those discussions. So again, what you can do depends on what you're trying to limit. So the NLRA provides employees, including non-union employees. I think we see NLRA and you think traditional labor only applies if the union's involved. That's not necessarily, that's not the case. So even for non-union employees, they have the right to discuss things that impact and to engage in protected activity, concerted activity to engage in these discussions that revolve around workplace conditions. So something like the terms and conditions of employment are likely going to include things like travel benefits or certain things related to actual employee benefits. So certain conversations are likely going to be protected under the NLRA. And in terms of prohibiting employees, we've seen some cases on this front fairly recently, some in the Black Lives Matter context in terms of employers with different types of regulations. Facially neutral bans, generally speaking, I think are likely going to be fine. If I think again, the type of, if you have, you know, for example, if you have an employer where people wear buttons or something, you want to make sure that you have a facially neutral application if you're going to try to restrict any type of speech. And with that, and I'm going to hand it over to Anne Marie, who's going to discuss some of the additional implications that come in and some Title VII implications.
Thank you very much, Elizabeth. So Title VII, you know, because of Roe, many folks were not aware that that there are other protections that still remain in effect in the employment context. The big one is Title VII. So Title VII does protect women from being fired or being subject to any adverse employment action because they have an abortion or contemplate having an abortion. You know, it also protects employees from termination or any adverse action because they decided not to have an abortion. So an employer can't take any adverse action against an employee because of the decision she made regarding whether to abort her pregnancy, regardless of which decision that is. Title VII does not generally require employers to offer health care insurance or to cover abortion, except in two circumstances. That when the life of the mother would be endangered if she carried the fetus to term, or if medical complications arise from an abortion. And this really poses an interesting question because, you know, on the one hand, Title VII would require an employer to provide the coverage in these two circumstances. But what happens if Texas and other states consider that that compliance to be aiding and abetting and you know, an abortion, and therefore unlawful under their state law? We think that Title VII would preempt those laws, but you know, given all that has happened, you know, it wouldn't be far-fetched for a state court judge to conclude otherwise. So, you know, right now we just, you know, we know this is out there. We expect courts to conclude that Title VII would preempt, but you know, we can't say for certainty that that definitely will be the case. Also, we predict that just more generally that there will be an uptick in discrimination and harassment claims based on pregnancy, religion, and political beliefs as people have discussions in the workplace that Elizabeth touched on. For example, you know, employees get into a heated argument, you know, one's pro-life, one's pro-choice. Down the road, one of them is terminated for unrelated reasons, but, you know, is convinced that it was because of the position that he or she took on abortion that was overheard by their supervisor. So we see those claims on the horizon, and they could be framed, like I said, either pregnancy, religion, political beliefs, etc. And with that, I am going to turn it back to Elizabeth to talk about a couple other issues.
Sure. So just very briefly, some other things that may come up are transfer requests. You may have employees wanting to transfer out of certain states into certain states. You know, in terms of looking at these requests, I think generally speaking, employers want to look at business necessity and make sure that there's not some type of pattern or practice in granting or denying these requests that could create some sort of inference of discrimination, and just something to be mindful of. Another thing, and I know we've touched on this in the context of different types of records and requests for records and court orders regarding some of these records. Something to be mindful of in terms of crafting policies, I think at a high level, is just, are these records going to be discoverable? And if so, what's contained in them? So what types of records relate to abortion-related benefits? Employers obviously need to document if somebody is taking some type of protected leave. For example, if someone does reach a situation where they qualify for FMLA leave, they're going to need to document it. But just, I think they'll want to be careful and mindful about how they're documenting these things and exactly what they're documenting. And with that, I'll hand it off to Anne-Marie for our last bit.
Thanks, Elizabeth. And just to add there, employers, that is one reason Jennifer alluded earlier to a broader leave or a broader benefit. And one reason for that is just, strategically, it is likely to cause less, maybe less publicity, less concern from some of these states like Texas. And for the same reason, if you have a policy, if you have a general leave for, time off from work to obtain health services from more than 100 miles from your home, and have a broad policy that refers to that, and then leave request forms that don't explain the purpose, that the employee, you don't ask the employee to indicate, that she's going to have an abortion. It's just time off for some sort of medical procedure. And quite frankly, in a number of states like California, employers aren't entitled to ask for diagnosis or medical facts. So just think you want to think strategically about your policy, the way it's written, and your forms, and what information you seek, knowing that other states, heaven forbid, could, issue subpoenas for those records. Next, criminal history questionnaires and background checks, just something to think about here. I don't think there's a yes or no answer, but certainly want to pose the question to get you thinking about it. Many clients run post-offer pre-employment background checks where they ask about criminal history. So, think about whether or not you're going to want to revise your criminal history questionnaires or background check forms to specifically exclude abortion-related convictions. And also, how will you respond to background check results that include, abortion-related convictions? Will you consider those as part of the decision as to whether to withdraw an offer, or will you not? And what types of claims, possible employees who have convictions for other crimes that are kind of at the same level in the state penal code might say, well, this is, discrimination, I'm, because I don't, you're not disregarding my conviction. At the same time, if as long as it wouldn't be gender discrimination, for example, if you consider a burglary crime, that's at the same level as abortion-related crimes in Texas, as long as you treat men and women equally with respect to the robbery crime. I could see, though, some adverse impact theories of discrimination. So just some things to think about.
Thanks, guys. I appreciate that. I know we're running a little behind schedule, and we want to get to the big topic a lot of people are interested in. Chris and Ben, you want to talk about ERISA preemption and employer risk?
Yeah, sure. Thanks, Diane. And I think the big topic is really more Chris than me, so I'll be brief. For those who are unfamiliar with ERISA, one of the purposes of ERISA was to create a uniform regulatory scheme that applies to nationwide employers. So a component of ERISA is that it preempts state laws that relate to benefit plans. Now, I think a lot of people are saying, well, if abortion coverage is in our benefit plan, then we're good, right? Unfortunately, that's not necessarily the case across the board. There are a number of exceptions. So let's talk briefly about those. So first, you would not have preemption with respect to state insurance laws as it relates to a fully insured plan. And sorry, we've been having some sort of false alarm active shooter drills here in the Wills Tower. So for the background noise and for those of us who are distracted, a lot going on. So I'll try and hang out as long as I can here. The second piece is, I think there's a lot of questions regarding when a law relates to state insurance plan, or I'm sorry, a benefit plan, and the court has really chipped away at the fringes of ERISA preemption in that regard. And we've got that sort of highlights on the screen here, but generally if it's core and substantive to the coverage, it should be preempted, whereas if it's just a cost implication, it may not be preempted. We tend to think that abortion restrictions or limits on the ability to offer abortion coverage through your plan or travel benefits through your plan are core to the plan, and as a result should be preempted. But there's another big caveat there, and that is that criminal laws of general applicability are not preempted under ERISA. Most of the laws that are out there right now with regard to abortion in the criminal context are probably of general applicability. But if a state were to pass a law, for instance, that said employers can't reimburse for travel to get abortion services in another state, that's pretty directed towards employer benefit plans, and there would be a good argument why that should be preempted. And then the final point, when we talk about like how we're structuring this, is it within our ERISA plan? Is it outside of our ERISA plan? An important point there is that in order to claim ERISA preemption, it has to be an ERISA benefit. And the more you make it look like an ERISA benefit, including having it in your plan, the better you are able to claim ERISA preemption in that context. Final point here, just some thoughts and takeaways. And I don't want to walk through all these necessarily because Chris is going to hit on some of them. We do think that if you have a benefit that reimburses in excess of IRS limits, if it's in your ERISA plan, Danita was talking about the tax limits, we think that should potentially still qualify. And then Leon hit on some of these state safe haven laws in some context. Keep an eye on those. There are a handful of states out there right now that kind of create a counterweight to some of these civil laws, these bounty style laws. And so if you are an employer operating primarily in a state, or your corporate headquarters are in a state that have a safe haven law, that may protect you and give you a counterpunch if someone tries to bring one of these civil bounty style laws against you. So with that, let me hand it to Chris to talk about the criminal side.
Thanks, everybody. Got this? Yep, here we go. So, went too far. There we go. So I think, and I'm touching on a lot of things that everyone has already spoken to. And obviously, I think the primary thing to take away from today is, think of things at a state level and then at a federal level, and interstate commerce and then preemption. So we're kind of looking at these things very much at a holistic level right now, as Leon spoke to, but ultimately this is going to be a very state by state analysis. Many of us, and we'll touch on this in a bit, have used Texas as sort of our benchmark because Texas has been and we assume will continue to be the most aggressive. Texas, the Freedom Caucus in Texas is the one that's issuing these letters to various companies. Texas is the one that has decided it wants to be, at least that wing of their legislature has decided it wants to be on the forefront of this. So, I think that's a litmus test for all of us to say, well, how far might a state go? But I think what's important to think about is what is actually in place right now. And we are all assuming, and I think we would all agree, that interstate travel for abortion care will become necessary. It's going to happen. There are no current state laws that actually specifically prohibit travel to another state. And as Ada touched on, Kavanaugh's concurrence talked about how, in his view, an individual traveling to another state, there would be no ability of a state to prohibit that. And I'll get to the Bigelow case. What Kavanaugh didn't do, though, is go as far as some of the prior Supreme Court authority on this. So while he said an individual might be able to travel to another state and that couldn't be prohibited, the question is going to be, well, what happens when that person comes back to their state? Could there be some some liability once they return, and that's sort of left as an open issue. There's no current state law that specifically prohibits paying of expenses related to out-of-state abortion care. So similarly, and part of the reason we have some comfort in saying that is they wouldn't be saying we're going to legislate, introduce legislation to do this if they thought they already had the legislation in place. But there have been attempts in several states to introduce legislation protecting the unborn child as a resident of the state. I think we need to pay attention to that. Georgia's tried to do it. Missouri's tried to do it. Oklahoma's tried to do it. In essence, saying that if someone is a citizen of our state and someone took them across state lines in order to do something that in our state would be criminal, could there be potential liability for that? Again, none of those statutes have been enacted, but we expect that certain contingencies of these state legislatures will introduce those. So what most lawyers, what most practitioners and scholars have been looking to as sort of the litmus test is Bigelow versus Virginia. It's a 1975 Supreme Court decision where a New York abortion clinic advertised in Virginia that they were ready, willing, and able to welcome residents of Virginia up to New York when abortion was illegal in Virginia, to have abortions in New York. The publisher of that paper was criminally prosecuted, and the Supreme Court reversed the conviction primarily on First Amendment grounds, which is important because it doesn't mean that we necessarily have black and white, black letter law in this. Even assuming that you believe the court that they're not just going to willy-nilly reverse precedent going forward. But they made a few statements in there that I think are very important to understand. They did say that Virginia couldn't prevent its residents from traveling to New York, echoing what Kavanaugh said. They also said a state doesn't acquire power or supervision over the internal affairs of another state merely because the welfare and health of its own citizens may be affected when they travel to that state. So that goes a little bit broader. That says that seems to imply that just because someone goes out of state to do something that would be illegal in that state, that when they return, you can't then prosecute them for doing something that was legal. And there are civil cases that have addressed this. These are not criminal, but they are important to understand, which is State Farm and BMW, where they said a state cannot punish a defendant for conduct that may have been lawful where it occurred. And obviously, we're assuming someone's traveling to a state where abortion is legal. And then the BMW case, that they can't impose sanctions on violators of its laws with the intent of changing their lawful conduct in other states. So these are all comments that are helpful. Unfortunately, they're not necessarily dispositive in this environment, but we think it is important. Quickly, Planned Parenthood of Kansas versus Nixon was a state court case in Missouri, where Missouri proposed this sort of hybrid concept of out-of-state travel, and it was a parental consent. This is pre-Roe, so pre-Dobbs, so when Roe was still in effect. So essentially, it was our requirement that a minor needs to get consent in order to get an abortion. We're going to carry that across state lines to states that may not require that, because the planning, the funding, all these things would have happened. Potentially the conception of the child happened in Missouri. So when they leave Missouri, we still have a vested interest in that. And it's sort of this hybrid in-state, out-of-state. And even the Supreme Court of Missouri rejected that theory and said that they can't basically have their laws have an extraterritorial effect. So again, some comfort in that, in that there is this concept of limiting the reach, in that particular jurisdiction. But we need to be aware of, various legislation that's been proposed. Several states have attempted to implement legislation for aiding and abetting, assisting. We've seen, many of you have seen the letters that have gone out to Lyft and Citibank and Sidley Austin from Texas saying they will criminalize financing of out-of-state care. However, if you look at SB 8, which was the civil law, the private attorney general statute, what's interesting about that statute, even in Texas, is it specifically carves out not imposing liability on the actual individual receiving the care, but on the provider. And it also notes that there has to be an underlying offense under aiding and abetting law. Well, if you go to a state where something is legal and engage in legal activity, there's a real question about whether then there's an offense as the statute is written. There's a Florida case involving adoption where Florida tried to impose a ban on people going to other states, taking Florida adoptees to other states and having them adopted in other states. And the only way that survived was because they specifically limited it to Florida and limited the definition of agency to an agency that could be anywhere. So these are the kind of battles that have yet to be sort of worked out. But so far, the fact that a state has its sovereignty and it has no extraterritorial effects seems to be holding. Hopefully I kept to my time and we have a few minutes. I know it's a lot to cover from all of us, but please, and since I'm the last speaker, again, follow up with any of us if you have questions on any of what we presented. We really appreciate it. I'll turn it back to you, Diane.
And we can stick around. Thanks, Chris and Ben. We can stick around for a few more minutes. If you have to disconnect, we understand. I think we can record a few more minutes. I understand.
You have to give them the code, Dan.
The CLE code. Well, I'm getting there. I still got slides to go too. You got to stick around the whole time for the code.
There you go.
But I will give you the code now before you have to listen to the support slides. So the CLE code, which you can put in for your continuing legal education credits, are SS, which stands for Seyfarth Shaw, SS 9388. So again, SS 9388. Okay, so this webinar today has been brought to you by our Reproductive Health Law Advisory Team. These are some of the key members of our team, but it's a much bigger team across our various practice departments at the firm, bringing people from all different areas together because there's just a lot going on here. You can access, I think we'll push out the slides for this to the attendees afterwards, but other support materials are available on our website at seyfarth.com. You can click through the landing page. You should see this right now. You can click through and get some any of our thought leadership or extra support materials out there. There we go. There is a delay. On your deck, there'll be some links here as well to our prior legal updates. We have a blog where we've pushed out certain materials. We have a podcast, and one of our episodes is specifically on this. This webinar recording will be out there. And we are creating, soon to be released, a gender and reproductive health state law tracker. So it'll have laws that impact the subject matter today. So abortion access, contraception access, but also gender reaffirming care as well, because there's a lot of state activity on that side as well. And it seems a bit related to us. So our tracker will cover all those topics together. So that being said, I wanted to kind of scroll through some of the questions that came in and try to hit what we can. Leon, I know that there's been a lot of activity just in the last 2 days this week from the federal agencies. One of our questions that came in, I think, has to do maybe with today's announcement by HHS. So there's been anecdotal stories, which I think are being shown to be true, is that patients showing up at a pharmacy trying to get refills of their prescriptions are being denied for medication that they're taking for, say, cancer or something, because that medication might also be used as a contraceptive or abortifacient drug, which the pharmacy is afraid to refill based on the state laws. So didn't we hear today about it from HHS on that exact topic?
We sure did. We heard today, just really about an hour or so before this started. It dropped in our email boxes, guidance from the Department of Health and Human Services Office for Civil Rights that addressed a number of scenarios. It was particularly directed at pharmacies where individuals could be going to pharmacies to seek medications either in connection with the passing of a miscarriage or might be seeking care for an ectopic pregnancy. and that in those cases, pharmacists, perhaps emboldened by some of these state laws, may refuse to dispense to those patients. HHS has explained that those kinds of scenarios, and they list a number of others, there's about 15 different scenarios that they point out, could be violations either of Section 1557 of the Affordable Care Act, which prohibits discrimination based on sex, disability, and other categories, or the Americans with Disabilities Act and other laws protecting persons. So they have gone on the record, and I do recommend that folks read that guidance that just went up this afternoon.
Yeah. And I'm assuming we'll get a poster and alert out about that as well, following up on yesterday's alert, which summarized the federal agency guidance. This is probably Ben, Jen, Danita, some combination of you guys. It has to do with delivery of benefits and the tax impact. If an employer wants to reimburse above the 213D limits, can they do that on a taxable basis, like through an HRA, or does that kind of destroy the tax preferred nature of the HRA itself? I don't know who wants to take that one.
Yeah. I mean, we've looked at this. I think there's two questions: taxation, and then whether it's an ERISA covered benefit, and they're two separate things, right? The tax code merely limits which expenses can be reimbursed on a tax-free basis, but any employer-provided medical reimbursement, which we think reasonably covers reimbursement for travel to receive medical care, should still be an ERISA benefit. So, how you structure that vehicle, I think there's a couple different options, but we think that can still be reimbursed on a taxable basis, and you could still have ERISA protection there.
Great. Anne-Marie and Elizabeth, there's a few questions that came in on your topic, and since that's not my practice there, I hope I'm even explaining or translating these correctly to ask you, but there was a question about whether there could be disparate impact issues if an employer has employees in multiple states and they're allowing, travel for some and not for others, or leave for some and not for others, across those workforces.
There could, and that's why I think to try to reduce the risk of those claims, to make your policies as neutral as possible and broader than just say abortion services. And at the same time, if certain coverage is unlawful in a particular state, then that fact will defeat a disparate impact claim. So I don't think there would be a viable disparate impact claim, for example, from an employee in Texas saying, well, you don't cover abortion here, but you cover it in California. But there could be, if you provide benefits, time off from work, travel benefits just for abortion and not for other types of healthcare that isn't available within 100 miles of their residence, so to speak. So that's why I personally think that broader benefits that don't specifically single out abortion are the way to go.
Very interesting. Jen, HIPAA privacy issues. There's a few questions about, tricky questions about the extent of HIPAA privacy protections where there's a law enforcement request, either because the underlying services may be illegal in the state where the law enforcement is located, or the reason for the pregnancy was due to a crime, rape, or incest. Do you want to? I think you touched on it a bit, but looks like there's some clarification needed on the law enforcement protections under HIPAA, or lack of protections.
Yeah, so we start with the general premise that HIPAA requires that protected health information cannot be disclosed outside of the health plan or outside of the provider unless you have an authorization from the individual or unless it's one of the enunciated reasons under the HIPAA regs. So in general, you start with the premise of the information can't be disclosed. if there is a situation where where law enforcement is coming to the health plan with a subpoena and court order to provide information, then it could be disclosed in those circumstances. But in the examples that were just released by HHS recently, there were some specific examples of, you know, somebody comes into the hospital with a miscarriage symptoms at 10 weeks, and say the state bars abortions after 6 weeks, and the healthcare provider has a suspicion that perhaps this person has taken abortifacient drugs and that has caused the miscarriage. In the example, the HHS knows it would be a breach, a HIPAA breach, for that healthcare provider to affirmatively go out and report that. It is because that reporting is not required by law. So I think that there is a concern that, you know, could law enforcement come with subpoenas and get information from health plans of who got services? Perhaps they would need a court order to do that, and that would be provided even under the HIPAA rules. But there can't be kind of just voluntary disclosures of that information without that type of mandate.
Right, not fully open, tricky issue.
Right.
And I guess I'll throw one out, maybe one more to Chris and Ben. There's a few questions on obvious concerns about having employees in states where abortion is restricted or even illegal. What if a state, I think that this gets to the preemption question on the criminal side, what if a state legislated that health plans may not reimburse for abortion services or travel benefits? Would that be preempted? Made it criminal for a plan to do that?
Yeah, I mean, you probably have two layers here, and I can answer the first part, which I think that's not a general criminal law of general applicability. So that's one argument. But I think, Chris, you want to talk what the constitutionality of a law like that?
Yeah, I mean, it runs into the Commerce Clause. I mean, it's both, right? So it's clearly, from a preemption standpoint, it is it's not of general applicability. When we talk about general applicability, we mean like a law that would just generally prevent theft or assault or whatever. So a law that's specifically targeted at abortion care is not going to fall into this general category. And then the second level of it is, to the extent that that basically what you're doing is prohibiting someone from, you know, essentially paying that benefit, you know, to someone for doing something that's legal in another state. I think there'd be serious constitutional challenges. Of course, if that legislation were to be actually enacted, I don't know that it will be, you know, an employer would have to, an insurer, you know, if it's that specific, it would have to potentially, you know, change the benefit or change its practices unless and until that was tested in court. I mean, we would, you know, if a law is put on the books and it prohibits certain conduct, and I think that's what's sort of happening with this pharmacy issue that Leon touched on. You know, they're saying, am I currently violating a law that's a valid law? And if I am, I need to act accordingly. The federal government then swooped in and said, no, there's an overriding sort of preemptive federal Commerce Clause prohibition on the prohibition. So, you know, those are the issues that are going to have to get sorted out. It's going to become a state and federalism issue in each case.
Right. Well, I think that's all the time we have. Ainsley, did you want to give any instructions for closing up about when the recording might be available? Or I don't know if we have that information yet. I see a couple questions about that.
So
right.
the program should be sent out right away after the it should be, the emails with the program should be sent out right away after the following the program. Yes.
Great. Okay. And thank you all for listening and attending. And when you get the materials, you'll see all our names and emails there if you have any follow-up questions. So we appreciate your time. Thanks.